So welcome to what promises to be an intriguing discussion on the theme of ecocide, a catchy word, a potentially explosive idea, and an opportunity that our speakers today are seeking to transform into an ambitious nuts and bolts legal mechanism to help fix this planet and to hold its worst polluters to account. Will it work? How could it work? I'm Andrew Harding, BBC Africa correspondent, coming to you from sunny Johannesburg, a place that should be the world's renewable energy capital, but somehow the politics here have conspired to stop that from happening so far, and we'll be talking today about ecocide's political obstacles. Before we go any further, I've been asked to thank the government of Vanuatu for sponsoring this event. Their ambassador in Brussels is sadly ill, but we have Mr. Drelly Solomon, First Secretary of the Vanuatuan Embassy, to make some opening remarks. Mr. Solomon.
Thank you, Andrew. Excellencies, colleagues, ladies and gentlemen, allow me first to welcome you at this event, Ecocide as an international crime, key considerations, which Vanuatu is proud to host. A special welcome to our guest of honor, the Honorable Foreign Minister of Finland, Mr. Pekka Haavisto. A heartfelt word of thanks is due to our partners from the Stop Ecocide Foundation and the Institute for Environmental Security who have helped to make this event possible. Friends, last year around this time, we convened in the Hague for the 18th session of the Assembly of State Parties. In the margin of this session, Vanuatu hosted a side event, which focused on the role of the ICC in addressing environmental destruction. His Excellency John Leach, Vanuatu's ambassador to the European Union, opened the event by stating that we are convening in a time of crisis. Ambassador Leach cited a marine heat waves in the Pacific, record-breaking heat waves in Europe, Hurricane Dorian causing death and devastation in the Bahamas, and wildfires in the Amazon and Australia as illustrations of this crisis. Little did we know that crisis would become the dominant theme for 2020, all across the world. We are in the midst of a global pandemic, which scientists have characterized as a spectacular and disturbing manifestation of the environmental crisis. In Vanuatu, the Solomon Islands, Fiji, and Tonga, we were hit by another Category 5 cyclone, Cyclone Arol, which caused death and widespread destruction of livelihoods and infrastructure. Central America has suffered similar devastation, with first a Category 4 and then a Category 5 hurricane, crashing into Nicaragua, Guatemala, and Honduras. All of this fits into a pattern of ecological breakdown. Friends, what gives us hope in time of crisis is solidarity. Solidarity with loved ones, acquaintances, and strangers. We also need a bold vision for change to channel our solidarity. As UNESCO's Director General, Madam Audrey Azoulay, suggested earlier this year, the ongoing crisis should be seen as a clarion call to fundamentally rethink our relationship with nature. A paradigm shift is needed across the board in the way we think, act, talk, but also in our legal system. Against the backdrop of crisis, today's side event also represents a step forward from where we left off last year. We are in the presence of 3 renowned experts who have agreed, along with other experts from different geographies, to start working on a legal definition of ecocide as a potential international crime. And we are joined by a renowned activist and member of the European Parliament who has worked tirelessly towards better legal protection of the environment, including through the criminalization of ecocide. As Vanuatu, we stand ready to play our part in ensuring that the ICC is well equipped to promote and ensure international justice in these rapidly changing times. Thank you, Thomas. Thank you very much.
Thank you very much, Drelly, and we wish Ambassador Licht a speedy recovery. And now, as a sign of how fast the conversation about ecocide is spreading at the state level, we can now zoom from the Pacific Ocean to the Baltic Sea and to Finland's Foreign Minister, Pekka Haavisto. I'm told he's particularly grateful to Drelly Solomon from the Vanuatuan Embassy for his comments. Here's the Foreign Minister's message.
Ladies and gentlemen, distinguished participants in this side event sponsored by the government of Vanuatu. As the Minister for Foreign Affairs of Finland and as a former Minister of the Environment and Development with a keen interest in global environmental issues, I'm happy to congratulate the governments of Vanuatu and Maldives for having initiated the international exchange of views on how to introduce into international law the crime of ecocide. The small islands states of the Pacific and the Indian Ocean are most dramatically threatened by the advanced warming of the climate and need the support of international community. As a member state of the European Union, Finland will do its utmost to combat climate change and alleviate its effects. Our own climate goal is to have a carbon neutral Finland by 2035. The criminalization of ecocide, when eventually approved and brought into force, will not have retroactive effect. It is therefore all the more important to ensure that such new international law would have a strong preventive effect. At the same time, it is important to recognize, as has been done by the ICC Office of the Prosecutor in its 2016 policy paper, that also the crimes already under the jurisdiction of the court, in particular genocide, crimes against humanity and war crimes, can be used to address environmental destruction. A lot remains to be done to reach agreement among the states parties to the Rome Statute to support the inclusion of the crime of ecocide within the jurisdiction of the court. The definition of ecocide as an international crime will be an essential element of that further debate. We follow this work with great interest and look forward to the report of the international group of experts established for this purpose by the Stop Ecocide Foundation. Thank you.
Okay, that was Finland's foreign minister, and as they love to say here in South Africa, all protocols observed. I have some very distinguished speakers to introduce now, and as you can imagine, they come with some impressively long CVs, but I guess that's why they've asked a journalist to come and wield the knife and, if needs be, the stopwatch. First up, Philippe Sands is a QC, a professor of law at University College London, a barrister, a regular fixture at international courts and tribunals. I last saw him in The Hague at the ICC's devastatingly sharp ruling on the status of the Chagos Islands, an instructive moment that showed how quickly the international status quo can crumble. Philippe is also a well-known author. Most relevant in today's context is his book East-West Street, which tells about the origins of another famous or infamous side, genocide. Philippe.
Thank you, Andrew, and thank you to the sponsors and hosts. I do want to begin by just paying tribute to Polly Higgins, whose work, of course, inspires us and takes us on. I have not been involved in the work of the Stop Ecocide movement. I've watched it closely. I teach international law, I teach international environmental law, and have written at least one treatise on that subject. So I've always had a big interest. But of course, here we're going beyond the established rules of international environmental law into the field of criminal law. Many national jurisdictions have criminalized harms to the environment. And the question now is whether to do that on the international scale. And from my perspective, it seemed to me that the time was right to start thinking very seriously, or even more seriously than Polly Higgins and Jojo Mehta and others have been doing, and try to broaden, if you like, the audience and the participants, including, most significantly at the end of the day, states who will have to decide whether to take this idea forward. I think it's worth perhaps giving a bit of context about international criminal law, which of course is a relatively modern and recent creature. Before 1945, the only international crime that had been really codified was what we call today war crimes, methods and means of warfare. And then in the summer of 1945, there were very dramatic changes. The catalyst was the decision of the Allies at the end of the war to create an international military tribunal to prosecute leaders of Nazi Germany for crimes committed during the period of Nazi rule. And new crimes were frankly invented and to a very large extent applied retroactively. And that, I think, is what caused me to think carefully and ultimately to agree to participate, and I'm very privileged to have been asked, on this working group with such a wonderful group of colleagues. So what happened in the summer of 1945? There were 3 new crimes essentially invented. One, which we'll put to one side for the moment today, is the crime of aggression, waging illegal war. It's the 2 others that strike me as especially pertinent for our thinking. After the horrors of the Second World War, the horrors of the Holocaust, the horrors of terrible acts of killings against many national communities, Roma, many religious communities, a decision was taken that international law needed to change, that limits had to be placed on the power of state over human beings. And that was articulated in 2 new crimes that came to see the light of day at the same time in the summer of 1945, and both are relevant to the concept of ecocide. One is crimes against humanity, which was essentially put into the Nuremberg Statute by a professor of international law at Cambridge University, Hirsch Lauterpacht. And the focus of crimes against humanity was the protection of the well-being of individual human beings. The second crime that came into being at that point was the crime of genocide, invented by another Polish jurist, Raphael Lemkin, and that is focused not on the protection of individuals, but on the protection of groups. And ever since 1945, those 2 concepts have grown side by side in parallel. I wonder, Jojo, if you could just put up now the doodlings of Raphael Lemkin in the year 1944. Some of you may have read the book that Andrew kindly mentioned that I wrote, which explores the origins of genocide and crimes against humanity. And when I was researching that book, I found myself in the archives, the rare papers and books library at Columbia University in New York. And I was ferreting around in Raphael Lemkin's papers, and I found this single sheet of yellow legal lined paper. It's undated. It must be late 1943 or early 1944, because Lemkin published his book with the famous chapter 9 titled Genocide in November 1944. So we know that it predates that. But essentially, this doodle is, for me, very powerful. I imagine him sitting at his table. He's worried about the well-being of his family. He's worried about the well-being of the world. He's wondering about his idea of creating a new international crime, which could prevent the atrocities that occurred. And you see here scribbling out more than 25 times the word genocide, but also other words, metricide and extermination and cultural. Bottom left-hand corner, you can see very clearly there the word genocide written out. And when Jojo and others asked me whether I would be interested in participating in the working group, I thought back to this sheet of paper. It's fine to take it down now, Jojo, thank you. And I imagined these 2 men, Raphael Lemkin and Hirsch Lauterpacht, working in the summer of 1945. They were separated from their families who were in Nazi-occupied Poland. In fact, it turned out that their families were exterminated without exception, parents, brothers, sisters, everyone. And instead of lying down in a corner and curling up and weeping, they didn't do that. They basically decided to bring to the table the power of ideas. And their ideas were these 2 new international crimes. And extraordinarily, they took off. Crimes against humanity was integrated into Article 6 of the Nuremberg Statute. Genocide was integrated into the indictment, actually as a war crime, and both were argued before the Nuremberg Tribunal. And subsequently, of course, the crime of genocide was codified in the 1948 Convention. Now, at the time that Lemkin and Lauterpacht and the states that drafted this thing were doing this, exactly 75 years ago, I've just participated. It was an amazing privilege to be with the President of Germany in courtroom 600 on the 75th anniversary of the opening day of the trial, 20th of November, 1945. They did not have a conception of other human and humanitarian and global interests that we should be caring about. The consciousness about the environment really only began in the early 1970s with the Stockholm Conference at the international level, and then of course took off 1992. Neroni and I were both deeply involved in that, what an incredible happiness to be back with you, Neroni, on this project. It's extraordinarily lovely. And then things really began to take off. And for the first time in 1996, in a case that Neroni and I argued for the Pacific Island states, and it's great to see Drelly Sonneman here from Vanuatu, it was the Pacific Island states that argued the environment when it came to the use of nuclear weapons. And amazingly, the International Court of Justice, for the first time in its history, in its advisory opinion of 1996, said, yes, protection of the environment is part of customary international law. This is how things develop in international law. People have to have ideas, people have to make arguments. That's what Polly Higgins did. And of course, 25 years on from that, we're now at a point where we recognize the extraordinary challenges we face, not just as human beings, but also in terms of our ecosystem, biodiversity, the climate system, rivers, oceans, air quality. I mean, I could just go on and on. All people, I think, on this call are aware of the enormous challenges we face. And for that reason, I was comfortable that the time has come to reflect on harnessing the power of the criminal law at the international level, as it is done at the national level, to effect change. I'm not starry-eyed. I don't believe that magically, suddenly, if you define a new crime or implement it in a treaty or in the Statute of the International Criminal Court, many of the challenges we face will suddenly disappear. Crimes against humanity have not gone away. Genocide has not gone away. But we have at least organizing principles. That's the change from the 1930s. And my own sense is the environment needs that. Now, it's a challenge. And those of you who've read East West Street and followed my work will know that I have a particular concern about the crime of genocide, because it has been defined in a way that sets the bar so very high that it is almost impossible to prove. I am involved in a number of cases that involved allegations of genocide, including, for example, the current case before the International Court of Justice, involving the allegations of mistreatment against the Rohingya community by the government of Myanmar, by the Tatmadaw. And that case is before the court. And we're all acutely aware that because of the definition of genocide, and in particular, the need to prove the intention to destroy a group in whole or in part, which is a difficult thing to prove because people tend not to leave bits of paper around saying that they intend to destroy a group in whole or in part. You're left to infer that intention, and inference is a very difficult thing. So there is a difficulty with the term genocide, and I think if we're not careful, the term ecocide may be hijacked in such a way to run as a parallel. And I think the challenge for the working group, whose terms of reference is absolutely limited to coming up with a definition, what happens to that definition is, or another definition, it will be for others to decide, is to take the best of the concept of genocide, the best of the concept of crimes against humanity, perhaps from war crimes also, which does have provisions in terms of the criminality of using the environment as a method and mean of warfare, and meld from that something that is workable, that is effective, that is not overly onerous, that doesn't, if you like, open the floodgates, but nevertheless deals with very real situations where one or more human beings recklessly or otherwise, or with intent, proceed to destroy the environment or a part of it on a massive scale. I think it's a challenging exercise. We are a very diverse group, which is exactly how it should be. I'm a passionate believer in the idea of a broad church, because debate and deliberation allows us to come up with something that is workable. And I can assure those who are beaming in from the Assembly of State Parties, and thank you for beaming in, that we will take very close regard to the practice of international courts and tribunals in looking towards something that really is feasible. But of course, what that will be is a matter for the future. But hopefully around 6 months from now, we will come up with some sort of definition which others can then comment upon, criticize, tear apart, support, do what they want to. Our job is to come up with a set of workable, effective, efficient ideas. And it will then be for others to decide what to do with it. Thank you so much for joining us today.
Thank you very much, Philippe. We will have a Q&A session at the end of this section, and do please feel free to start sending in your questions now here on the sidebar, the Q&A bit. There are 4 questions already lined up. But before that, our next speaker is Kate McIntosh, lawyer, academic, and expert on international criminal law and its sizable overlap with environmental justice. Hers is a legal journey that began in the ruins of places like Rwanda and Bosnia, moved on to international tribunals, and more recently to a frontline role in this emerging field of ecocide. Kate heads the Promise Institute for Human Rights at UCLA and is a member of the new Ecocide drafting panel. Kate.
Thanks very much, Andrew. And it's wonderful to be here with these panelists, and welcome everybody that's tuning in. So I'm just going to start by talking about the history of ecocide as an international crime, and then briefly outline some of the major challenges that we'll be facing in drafting a definition. So ecocide, the term, was probably coined by Professor Richard Falk, who's these days down the road from me in Santa Barbara, back in 1973, when he proposed an international convention on the crime of ecocide in response to the use of Agent Orange and environmental destruction during the Vietnam War. Clearly drawing inspiration from the Genocide Convention, Professor Falk's proposed definition consisted of a number of enumerated acts, which included the use of weapons of mass destruction and the forcible displacement of people and animals in pursuit of military or industrial objectives, interestingly, committed in time of war or peace with intent to disrupt or destroy, in whole or in part, a human ecosystem. So you can see where he drew his inspiration from the Genocide Convention. Soon after this, the destruction of the environment during armed conflict or for other hostile purposes was prohibited by 2 new legal instruments. In 1978, the Convention on the Prohibition of Military or any hostile use of environmental modification techniques, which understandably has a shorthand, the ENMOD Convention, and in 1977, the year before, the first additional protocol to the Geneva Conventions. And both of these prohibited or introduced the terms widespread, long-term, and severe, or in the case of the ENMOD Convention, widespread, long-term, or severe damage to the natural environment. So in 1985, the UN Human Rights Subcommission on the Prevention of Discrimination and Protection of Minorities proposed broadening the definition of genocide to include adverse alterations to the environment which threaten the existence of entire populations, for example, through nuclear explosions, chemical weapons, serious pollution, or acid rain, and the destruction of the rainforest. And I wanted to draw your attention to how this definition, as well as Professor Falk's ecocide, include the element of human harm. So the subcommission talks about acts which threaten the existence of entire populations, and Professor Falk's definition required the environmental destruction to disrupt or destroy a human ecosystem. The ENMOD and Additional Protocol 1 provisions, on the other hand, prohibit destruction of the environment in itself. And these 2 approaches are sometimes characterized as anthropocentric and ecocentric, and this is one of the issues that we'll have to deal with on the panel. So by 1991, the ecocide issue, albeit not by that name, had reached the International Law Commission, then busy with the draft code of crimes against the peace and security of mankind, which had been busy with for quite a long time by that point. But its draft that year included an Article 26, which was willfully causing or ordering to be caused widespread, long-term and severe, again that language, damage to the natural environment, drawing on that language from Additional Protocol 1, but crafting a standalone international crime that could be committed in times of war or peace. Now that Article 26 was dropped by the International Law Commission from its draft code in 1995, when the list of crimes was whittled down significantly. And this was reportedly in response to the strong opposition, criticisms or reservations of certain governments, that's a quote, possibly because of the implications that it was seen to create for the use of nuclear weapons. However, the Commission did maintain the idea of pursuing willful and severe damage to the environment as a war crime. And as you know, the Rome Statute of the International Criminal Court, which was drafted just 3 years later in 1998, does include, as Philippe referenced, the war crime of causing widespread, long-term and severe, again, damage to the natural environment in international armed conflict, although it introduces an additional test of proportionality to military advantage anticipated. So that's the 20th century. It was about 10 years into our current century that the term ecocide, as well as the project to use international criminal law to protect the environment, was resuscitated in a number of parallel private initiatives. And notable amongst these, of course, is the work of Polly Higgins, who Philippe mentioned, and I think who we can thank for being here today, the co-founder with Jojo Mehta of Stop Ecocide Foundation, our host today. And Polly Higgins probably did more than anyone else to raise awareness and to build a movement behind the creation of this new crime. I should also mention though 2 French initiatives, one led by Valérie Cabanès and one multi-year, multidisciplinary initiative led by Laurent Néret, which led to the drafting of a full proposed convention against ecocide in 2015. Which brings us to today and our current efforts. So as you've heard from Philippe and from Andrew, we're about to start work on drafting this crime of ecocide that can be proposed as an amendment to the Rome Statute. And we will of course be looking to draw inspiration from these earlier proposals and fashion something that fits in the really very recently developed and still developing framework of international criminal law and the Rome Statute in particular. So I'll just briefly touch on a couple of the issues that we'll need to address in these efforts. And here I'm drawing on the work of an expert group of mainly international criminal lawyers that we convened earlier this year at UCLA. And please see the link in the chat for the full report of the work of that group if you want to dig in any deeper. So 4 kind of top line questions that I think we're going to have to face. First of all, do we go for a broad definition that captures climate change or a more narrowly focused massive environmental damage? Climate change or emissions-based crime is, potentially the most urgent issue for us to address. And I think we're all motivated by trying to deal with this through international criminal law, but it's certainly much more difficult than dealing with other environmental damage such as pollution, deforestation, although of course that also leads to climate change. If we look at the climate change or emissions-based crime, what acts would be punishable? If we're focusing on fossil fuels, for example, would it be extraction? Would it be refinement? Is it sale or is it combustion of fossil fuels? And then especially in relation to a climate crime, how do we set a threshold so that only the major emitters would be caught by the law? Would this be around volume, for example, a percentage of global emissions or an actual amount of emissions? Or do we take a different approach and introduce elements of behaviours already considered criminal, such as fraud or corruption, into the definition of the crime? I've already mentioned the ecocentric versus anthropocentric issue in the ecocide definition. So do we punish harm to the environment per se, or does this have to be linked to human harm? If the definition of the crime includes human harm, then this will have to be proved in each case, which could be challenging because of the time it takes for human harm to manifest from environmental destruction, or the time it can take. Think of the slow yet accelerating impact of climate change, for example. An ecocentric crime, which talks only about harm to the natural environment, will be easier to prove. And finally, as was already mentioned, any new crime will be forward-looking due to the principle of legality. It will be impossible to capture historical emissions. How do we deal with the problem of skewing responsibility unfairly, potentially towards the global south? We may need to find a criminal law equivalent to the common but differentiated responsibilities principle adopted by the UN Framework Convention on Climate Change. So these are just a few of the issues that we'll be facing. Thank you very much, and I look forward to our conversation.
Okay, thank you very much, Kate. Our next speaker is from France, a nation that seems to be pushing for a global leadership role on ecocide, or perhaps it's trying to avoid hard decisions at home by focusing on the bright lights of the international stage. Marie Toussaint is a jurist, a leading French environmental activist, and a member of the European Parliament. Earlier this year, she initiated the creation of the International Parliamentary Alliance for the Recognition of Ecocide. Marie.
Hello. Hello, Andrew. Hello, everyone. I'm really happy and honored to be here today with all these beautiful speakers. And I can really feel that something is moving really deep. And as Kate McIntosh underlined, in the last years, we've seen this movement from being nowhere in terms of discussion about ecocide, and suddenly everyone is finally taking action throughout the world. And I thank also Mr. Solomon for what you did, for your speech, of course, but also for the really active role that Vanuatu took in this really important battle. Yeah, I do believe that moving towards an ecocentric international criminal crime is kind of a revolution, at least from Occidental philosophy. And that might be also why this is so hard. It's not only about the legal difficulties that we face, and we've seen and discussed already that there was a lot of difficulties in elaborating the right definition that can be efficient, but also really clear. But this is also about changing the way we apprehend nature and the ecosystems, and the way we interact with nature and the ecosystems. So in France, we are not there yet, actually. Valérie Cabanès is working for 10 years now, has been working for 10 years, pushing for the recognition of ecocide, and she had the help also from Laurent Néré and a few others who worked on this term, but it remained quite confidential until last year. And in August 2019, we heard our president, Emmanuel Macron, denouncing the ecocide happening in Brazil with the inaction, actually, of Jair Bolsonaro in the Amazonian forest. It told the world, then the Pope also used the word, and it began to be, to receive some kind of attention. And we had a French Citizen Assembly on Climate. This French Citizen Assembly on Climate has presented its conclusion last June, but you just have to know how we happen to have a Citizens Convention on Climate. And basically, 2 years ago, we launched a climate litigation case against the French government for climate inaction, which got more than 2.3 million people supports who signed the petition in support of this climate litigation action. We had a lot of youth, but also adults walking on the streets for climate, especially after the demission of our environment ministers. And we also had a very strong mobilization from the Yellow Vest movement, who are not being activists against climate or against climate policies, but against the fact that those policies were unfair and relying too much on the poorest and not enough on the richest, who are the ones who pollute the most. And all the numbers that we've got since then confirm that intuition from the Yellow Vest movement that we need to have a climate justice policy. But the president and the government were stuck in this crossed mobilizations, giving supports and supporting each other. So we decided to launch a Citizens Convention for Climate with 150 persons picked randomly. And they had to work on proposals to reach our climate goals of 40% of reductions of emissions by 2030. Right now, with the decision from the EU this night, we'll have to go upper. But the Citizens Convention made 149 proposals for climate policies, among which one of the 3 biggest ones, which they asked for to be presented in a referendum to the French people, is the recognition of ecocide. And the president committed himself to push for the recognition of ecocide at international level already last January, but we haven't heard anything about him or his government doing nothing in that regard, by the way, so we'll need to be cautious. But also then say, okay, we're going to study what we are going to do inside of France, on our territory, and see what is possible. And in June, when the citizens proposed a formulation for the definition of ecocide in the French law, the president said, okay, it's not good enough, it's not precise enough, it might be not constitutional. So they said, okay, we're going to work again on it. And then they gathered a few NGOs, a few lawyers, and we've been working since then on definition. But the government didn't rely on this definition, didn't even discuss the definition that we were trying to work with them. And they used the term ecocide to describe a new crime that they want to enter in the law, but which doesn't correspond at all to the ecocide crime. What's more, we've got the recognition of autonomous crimes against the environment in Italy since 2015. But France is still linking the environmental crimes, even in this proposal, resulting from the Citizens' Convention, to the violation of administrative provisions. Well, we can dig into that further if that interests you, but just to say that French government is really refusing to recognize the intrinsic value of nature. We still think that nature is, something that we can use to serve our interests, even though it must be a bit restricted. So that's about France, and now we're trying to fight for Ecocide not to be emptied from its content, especially since we are still expecting our government to go and support and defend the recognition of Ecocide at international level, but we hope that it's going to be on the definition that will be offered by the panel, and not the definition that they tend to give to the Ecocide crime inside of the French law, which would be a real catastrophe. So outside of France, because we are also talking Ecocide in different places of the EU, and I've heard with a lot of pleasure the Minister for Foreign Affairs from Finland today. But things are also moving in Belgium, where we had first Samuel Kogolati, who is a member of the alliance Andrew talked about a bit earlier, who presented a motion in the Belgian Assembly to recognize Ecocide in internal law, but also to support the recognition of Ecocide at the ICC level. And it didn't have the time to work so much because there was a new government that was formed, and the new governmental alliance decided to support those proposals. So they are right now working, and each ministers have to present how they will contribute to the recognition of Ecocide both at internal and ICC level, which is a great step forward. And this is one of the member states of the EU. So this will also be useful for the recognition of Ecocide in EU law. Then we also have Sweden, where for a long time we have two women working for the recognition of Ecocide. One is Pella Thiel, and the other is Rebecca Lemoine, who is also a parliamentarian, member of the Alliance. And they've been pushing for the recognition of the rights of nature and of Ecocides for the last years. Well, we got very good news in the last weeks, months, because coordination of political parties asked and required for the recognition of Ecocide, and asked the Stop Ecocide Foundation to bring them a definition that would be suitable, which led to the formation of the international panel, which Philippe Sands is chairing. But of course, Sweden is not new to the recognition of Ecocide, because after the use of the Agent Orange in Vietnam, the late Prime Minister Olof Palme opened the first international conference on the environment, the Stockholm Conference in 1972, by denouncing the ecocide that was happening in Vietnam. So that's where we are right now. Of course, we could have had help from the UK, where the ecocide is also discussed, for instance, by MP Caroline Lucas, who is also a member of the Alliance. But of course, we are right now finalizing the Brexit deal or no deal, we'll see. Well, we'll still have maybe an ally there at some point. But inside of the EU, then we also have a big discussion on what is possible, and we are gaining ground. We're not there yet, but we are gaining ground. We will most definitely win first on the call from the European Parliament for the recognition of ecocide at the ICC level. This is something that is feasible, and I believe not in such a long time. Already, we've got 2 votes in one of the committees of the Parliament, then it needs to be confirmed in plenary, of course. But we've got 2 votes from the Development Committee to recognize the ecocide at the International Criminal Court level. We haven't yet won anything inside of the Parliament or anywhere else on the recognition of ecocide in EU law, but things are moving, and we are seeing more and more members of Parliament coming to us to know how they can help, how they can support within the EP, and we have several texts in front of us that are coming. Just before telling you about these next steps that we have in the agenda, just to also let you know that after President Macron used the word ecocide in August 2019, I asked the Vice President of the Commission, Frans Timmermans, who is responsible for the Green Deal, so for the environmental policies, ecological policies in general. I asked him about ecocide. At first, he didn't answer, but then when coming back to a presentation in front of the committee, he didn't make any promise, but he talked about the Pachamama, the rights of Mother Earth, and he said that we didn't want ecocide to happen anymore in the world, which is quite promising because of those steps and the agenda that is in front of us. So what we would like to see is a commitment from the European Union and its member states to support the recognition of ecocide at international level, of course, and we are coordinating for that. But we would also like to see ecocide recognized in EU law, which can be done whether through a new regulation for the recognition of ecocide, which would be the best thing that we can have, but we are also in the process of revising the directive from 2008 on the protection of the environment through penal law. And that might be harder and not really legally appropriate, but we can see that there is a discussion going on also with the Commission and quite a number of MEPs who would like to see the word used in this directive and us working towards the recognition of ecocide, or at least reinforcing its links with human rights and the worst crimes that are already recognized through the Roma Statute. So just to end with this, well, when I say that we are coordinating, we are of course several members of parliaments from EU, different parliaments, the EP, but also national parliaments, who have gathered in the Ecocide Alliance, whom I will also send the link to you. And we also have members of parliament from the Philippines, from Brazil, and from the US. And we were 10 when we launched the alliance in October. But of course, we would like to have many more MPs to join us. And we pay attention though, because too many MPs are using the ecocide, as Andrew stated at the beginning, underlined, as you know, some kind of umbrella. They say they want the recognition of ecocide, but they use it also to greenwash themselves and not do anything inside of the country. So we're going to be really careful, but please, if any of you know parliamentarians who are sincere in their will to recognize ecocide, also tell them about the Ecocide Alliance. And I see that Jojo, whom I thank, put the link in the chat. Tell them to join us. Would be really happy to work with them and to support the work from Stop Ecocide and the international panel.
Okay, Marie, thank you very much. Our last guest speaker is Neroni Slade, who hails from Samoa in the Pacific Ocean, where it is already tomorrow. So we thank him for staying up very late there. He was one of the first elected judges of the ICC in The Hague. He's had a long diplomatic career at the UN and elsewhere, and has spent decades fighting for the rights of small islands and drawing attention to their unique vulnerabilities in the face of what I presume he would also call ecocide. Neroni.
Greetings to you all. My role, as requested, is to provide a personal perspective on the relevance of ecocide to our Pacific Island communities. The Pacific is a region of three major cultures. Melanesia, of which Vanuatu is, Micronesia, and Polynesia, of which my country Samoa is. Pacific people, ocean travelers, among the most celebrated of ancient navigators. They take seriously their place and responsibility for the oceans and its resources, and the Pacific is our home. This is a vast ocean, the largest and deepest in the world, an ocean of dominant forcing in the natural behavior and balancing of the global biosphere. The explorers of the 16th century call these the peaceful seas. And so it is by the deepest desire of the Pacific communities to see our home environment and our islands preserved, and for this great ocean as holding out for humanity, the promise of its natural abundance, and above all, for the purposes of international peace and security. But alas, it is not to be. We know that the Pacific Ocean is under significant stress, if not in fact in peril, for it is being systematically misused and abused, mostly through wanton and uncaring human activities. The ocean's plastics problem alone has been recognized since the 1960s. It has since expanded more disastrously today in accumulation seen around the world as giant floating garbage patches, the largest of which is said to be in the Pacific. Tropical and subtropical waters of the Pacific Ocean host large areas of the world's coral reefs. These vital systems now bear the brunt of climate change bleaching or die-offs from ocean acidification. Now, all of these combine in a situation of utmost seriousness for the Pacific Ocean indeed, for all ocean systems. But there are other factors which substantially compound our already environmentally precarious situation. In just the past century, the Pacific was an active theater of war. Our Pacific communities had no part in the causes, but they became the object of the atrocities and the scourge of war and the untold sorrow brought by war. And worse, our region has been the testing ground of weapons of mass destruction. The litter of war, wrecks of military ships and aircraft, hulking weaponry and unexploded ordnance can today be found in many Pacific islands. In the Federated States of Micronesia, for example, there are 60 military wrecks in the lagoon of Chuuk, which retain large stores of oil now reported to have begun leaking. Grave as that is, there is much more that we do not know of the environmental damage and consequences of the prolonged and the extraordinarily extensive atmospheric and underground weapons testing conducted by 3 different colonial governments over 50 years between 1946 and 1996, over 10 different sites in the Pacific. From 1946 to 1958, the United States conducted 67 atomic and hydrogen bomb tests in the Marshall Islands alone, at the atolls of Bikini and Enewetak. Philippe Sands has already spoken of nuclear weapons, so I will leave this at that. But Mr. Moderator, all this amounts to a rather serious situation. But with the few minutes I have, allow me to speak also about climate change in support of the concerns expressed by the distinguished representatives of Vanuatu and the Maldives before the Assembly of States Parties, as they did last year. It is, of course, a matter of public record, and I'm sure known to you all, that with their near negligible carbon emissions, small island developing states are amongst the least responsible for global emissions, but they are among the first to be struck and most severely to be affected by climate impacts. Their predicament is made more serious by the very conditions of their vulnerability, the unfairness and disproportionality of it all. The fact that these small communities simply do not have the coping capacities or the resources and technology to defend themselves and to deal with the disasters that occur. Almost routinely now, Pacific islands suffer cyclone devastation many times their GDP. Vanuatu lost some 64% of its GDP to the Category 5 Cyclone Pam in 2015. Cyclone Winston in 2016, another Category 5, killed 44 people in Fiji, with billions of damages, near 30% of that country's GDP. In April this year, as Streli Solomon has already mentioned, on top of and in the early raging days of the COVID pandemic, Cyclone Harold yet another Category 5 wreaked havoc of many millions of dollars in Vanuatu, in Fiji, and in Tonga, one after the other. Significantly, as the prediction of science has been for so long, these cyclones, the so-called super cyclones, have become more destructive in their frequency and high wind intensity. The struggle for survival in island regions is encompassing and it is real. For the very smallness of islands puts the entire ecosystem at risk. In all regions, this creates mounting challenges to the sustainability of development and to the security of human populations. It means that severe climate impacts add substantively to the reversal of poverty reduction efforts. This is an oceanic region of hydrological and ecological uniqueness. And we know from existing reports that there will be, indeed, there already are, adverse effects on fragile marine ecosystems, including fish stocks. With worsening climate impacts, a particular concern will be over the disruption and displacement of populations. Indeed, it has become necessary to consider the options when sea level inundation leads to loss of territory and the implications for the very integrity and the sovereignty of island states. Sea level rise and attendant storm surges and flooding are already significant problems. People and properties have had to be relocated by government directives from living or remaining on specific islands like the atolls of Bikini and Kili in the Marshall Islands and Kataret Atoll in Papua New Guinea. These low-lying communities, including Kiribati and Tuvalu, are literally now being confronted with the reality of diminishing populations as people face the difficult, if not the inevitable, choice of out-migration and leaving islands altogether. Internationally, the 42 countries from around the world work together and negotiate through their Alliance of Small Island States, AOSIS. AOSIS celebrated 30 years of its existence just last week. For that entire period, island countries have been persistent about the seriousness and urgency of climate change, and with their repeated calls for effective protection, equity, and fair treatment. They fear that what happens to the smallest will inexorably happen to others, as demonstrably is already occurring around the world. Now, if island countries have done anything, I believe they have served as the global frontline warning system, and they have brought to the international debate an essential ethical dimension. Island country concerns have been pursued at the highest levels, including before the United Nations Security Council, to press for the recognition of climate change as a serious threat to international peace and security. They will continue to express these concerns. They are the genuine concerns of people facing real and imminent danger. Remember, climate change is a global challenge, not a small island's problem. The Paris Agreement stands for this very purpose: international responsibility, the international acknowledgement of the magnitude and the immediacy of climate change. We all need to act together to make the Paris Agreement a reality. Never before has the need to secure the core principle of the Climate Change Convention become more imperative. The need, that is, to protect the planetary climate system for the benefit of the present and future generations of humanity on the basis of equity. Island communities believe very deeply that ultimately, especially for the small and the vulnerable, it is justice and the rule of law which offer the most effective protection. Mr. Moderator, much of what I've touched on, if in fact not all, were on the table at the Rome Conference, though not necessarily all resolved. They are therefore the unfinished business of Rome. Issues like global environment, which remain, like the issue of global environment, which remain within the principles and the fundamental underpinnings of the Rome Statute. May I say that I share fully the wide admiration expressed for the Ecocide initiative. Indeed, what I have said is in support of Ecocide as an international crime under the Rome Statute. There cannot be a more demanding moment for it now. My own view is that this effort will contribute substantively to the moral authority of the International Criminal Court and its true purpose that is to serve to guarantee lasting respect for and the enforcement of international justice, and more so towards ending impunity for those who wantonly commit the worst excesses of environmental damage. Thank you, Mr. Moderator. Thank you all.
Many thanks, Neroni. We now go to the question and answer section. We have nearly 400 participants, so I can see 52 questions already. Many of you will know how this works on Zoom. I think if you can click on that thumb on your favorite questions and push them up to the top, then we'll get, hopefully, to the most popular questions, and not too many of you will be left feeling that your questions haven't been answered. Also, if you can try and indicate to whom, which of our panelists you prefer to talk, but since that hasn't happened that much yet, I will kick off with Philippe, and elsewhere, if people would like to, amongst the panel, if you just like to sort of unmute yourself and also weigh in as and when. But let's start with two very similar questions at the top of our list here from Peter Splinter and Roberta Spiteri, both basically looking at asking why it is more advisable to invest time and resources in establishing a crime of ecocide than in making better use of existing norms and procedures to address environmental destruction. And with a follow-up on that, why not just expand the notion of crimes against humanity? So Philippe, over to you on that.
Sure, thanks. Well, I mean, they're both excellent questions. I mean, on the first question, why put time and effort into this? I was careful to say I don't imagine this could ever, as such, on its own be a magic bullet. It can't sort out all of the wrongs and ills that we face. But it was so also in 1945. Everyone knew that you needed to address the root causes of human wrongdoing. And that applies equally here. So we're going to have laws and conventions and practices and policy guidance and other sort of incentives to get people to treat the environment in a respectful and decent way. But one of the sort of arrows you've got in your quiver, so to speak, is the criminal law. And it has not been marshaled at the international level. It's an interesting question as to what the consequences of it being marshaled would be. But I know from my own practice as a barrister that the moment you put criminalization on the agenda, particularly of individuals, that's what's crucial, it does have the effect of concentrating minds, and concentrating minds of government lawyers and high government officials and people who work for corporations or associations or NGOs in some cases is not a bad thing. And for that reason, I think it's not a zero-sum game, it's not either or, and it's a useful thing to do, not least because, as I've seen just from the outpouring of interest since this was announced, there seems to be amazing interest in this. I mean, Marie made the point, on pourrait parler en français, Marie, mais je reste en anglais. I mean, it's astonishing. I've been astonished by how much interest there is, the number of people who've sent proposals and ideas and things. And I think part of it is about raising consciousness. And that relates to the second question. Yes, you could, you know, amend the Statute of the International Criminal Court and put in a new category of crimes against humanity. And it may be that that is what we end up doing. But what we know from what happened in 45 is that words really matter. If an American president says that a war crime is taking place, X or Y, or crime against humanity, frankly, it doesn't get a lot of interest. The moment the president calls it a genocide, the media attention is transformed. Words really matter. So it may well be, I'm not saying this is what will happen, that we end up with a definition of ecocide, which has the coat of that word, but in fact, the innards are a form of crime against humanity. But the most important point, I think, is to move away from a purely anthropocentric approach. That's what interests me. The best law review article I've ever read, literally, is by a fantastic person called Christopher Stone, who wrote an article in 1972 called "Should Trees Have Standing? Run, Don't Walk," to get hold of that piece. And it posits the idea that we should not only be focusing on well-being from a human perspective, from an anthropocentric perspective, but also from the sense of well-being of the protection of the ecology itself as an end in itself, not just because it protects us and makes us better. And I think that's the essential reason for not simply putting it into an anthropocentric definition of an international crime, but actually going the extra mile, as Lauterpacht and Lemkin did in 1945, and saying new times call for new crimes, and the protection of the environment by the criminal law is needed as an end in itself. That's, I think, the reason to go that route.
Okay, thank you, Philippe. Let's just move on to the next question, and perhaps Kate, you might want to answer this. Wendy Wiseman asks, if ecocide is criminalized, how would the continued refusal of the US to sign on to the Rome Statute affect the potential to prosecute US corporations?
Yes, that's a very that's a very good question. So it would definitely be a barrier, but as people know, there are a number of bases of jurisdiction under the Rome Statute. So there is territory, most obviously territory and nationality. So if a US corporation were also to have subsidiaries in a country which was a party to the Rome Statute, for example, I would have thought that that would open up some possibilities. But we could also look at the effects. So where is the crime committed is a question that's often discussed by lawyers, right? So if the effects manifest in a territory which is party to the Rome Statute, I would think that there would be a pretty robust basis for proceeding against the organisations, or the individuals rather, that were responsible for those effects.
Okay, thank you, Kit. Let me ask this next one to Marie. It's focusing on definitions, which Philippe had already touched on, and it's talking about a particular issue in central Italy and asking fundamentally, is the degradation of soil quality after many years of intensive monoculture to the point that no crop can be grown without artificial chemical stimulants, is that also an example of ecocide? Marie, if you want to unmute yourself, there you go. Thank you.
Yeah, I'm here. That's a tricky question. Philippe explained that well. I believe that when we have a genocide, we don't talk about genocide at each time there is an attack towards human beings, and maybe the definition that we gave to it was a bit too restrictive. But we have to pay attention, because when we talk about genocide, then it really attracts people's attention. And we have the same challenge with ecocide. We have to define it in a way that could embrace a lot of situations and really restrict the attacks, the damages to the environment. But at the same time, we should still make it something quite exceptional, right? So it depends on the situation. Of course, the fact to expand some toxic products on the soil can be an ecocide. For instance, in France, I believe that the use of chlordécone in the French Antilles, in the French Caribbean islands, can be considered as an ecocide. But it depends on the scale and on the extent of the damages. But then maybe I wanted also to rebound on the question of why ecocide and not the rest, which is linked to the discussion that we're having right now. And I do believe, when I look at what happened in France, we actually have a penal law, penal environmental law, that is the least used category of law in France right now. There is no political priority given to that. And even at international level, when you see that environmental criminality is one of the major sources of financing of, for instance, armed group and terrorism, you don't see the political priority there. Even when you have such a pandemics, which is linked somehow to environmental criminality, you don't see the political priority. So, you know, asking for ecocide is really important. As such, it can also help to pass this revolution I was talking about in the beginning, going from the anthropocentric to the ecocentric approach. But this also attracts attention of people on the fact that we have, you know, still a lot of holes in environmental law, in environmental penal law underneath, and that this hole needs to be filled. And you know, this is helpful to have the ecocide goal as a way also to enforce all that is under and that is still not enforced. So I really do believe that not only the ecocide campaign has, you know, a goal as such and in itself, and it's a very important goal, but also that going in that direction will help us mobilize and strengthen all the rest of our legislation that really needs to be bettered, improved.
Okay, thank you, Marie. I'm going to throw this one over to Samoa and to Judge Neroni. This refers to the crime of ecocide and specifically to deforestation. If we have a crime of ecocide, do you think it would be possible to also prosecute third parties who, for instance, buy wood from illegally deforested areas for aiding and abetting ecocide?
Aiding and abetting is a criminal law notion, and it's part of the elements of it. But it's ultimately, of course, depends on how we can prove it. All these are very rather complex matters. I think in reality, it has been said before, the value of criminalizing ecocide, deterrence, is a part, a very substantial part of its necessity, I believe. But I think third parties to the crime, it will be largely controlled, have to be controlled by the evidence that is ascertainable and evidence of the necessary standard. We will certainly need to give very careful consideration to it. I think it is essential to build on the definitions that already exist for genocide and crimes against humanity. I believe that the ICC Prosecutor's Office has already developed a policy approach to environmental aspects that are raised in complaints against the existing crimes of under the Rome Statute, and I think this is a useful development. Very much agree with other colleagues who've said that we do not have any illusions at all of the complexities of the task before us.
Okay, thank you very much, Judge Slade. This next one touches on something that Marie Toussaint had already spoken about concerning France. So maybe we should ask Philippe for his view on this. What are your views on national initiatives attempting to define ecocide in their national legislations that may not seize the full magnitude of the offence and may therefore prevent further legal evolution or from efficient prosecution of ongoing serious harm to the environment? And Rosalie Biot specifies this French proposal on defining ecocide. Philippe.
Look, I mean, some national developments may adopt an approach which we like or which we don't like. But the bottom line is, at the end of the day, the international arena is only ever going to be a backstop. You know, there are so few cases in the existing international crimes that the idea that somehow magically a definition of ecocide at the international level is going to dramatically turn things around, I think, is misguided. What it can do is it can catalyze thinking. And that's what's happened with crimes against humanity and genocide. And for example, there are no international prosecutions right now in relation to the allegations of genocide perpetrated by ISIS in northern Iraq and Syria. But Germany is using the international definitions of genocide and crimes against humanity to bring extraordinary proceedings in its own national courts. So I think at the end of the day, it's going to be first and foremost for national courts to deal with these issues. And maybe what we can do with our work, I don't know, is assist in coming up with a definition that is useful for the national level. But at the end of the day, if it doesn't happen at the national level, it's not going to happen. So there's got to be a sort of porous relationship, an interplay between the domestic and the international. Otherwise, it's not going to work. So broadly, the answer to the question is I strongly support national initiatives, but ultimately we need to move to a direction in which the content of the laws applied at the national level bear some sort of resemblance to what the international definitions are. And that's what's happened on crimes against humanity, war crimes and genocide. And that's the way I think that we need to go.
Okay, thank you. The next question feels very 2020, very Trumpian. How does obfuscation of the science and deceiving the public regarding facts and particular acts of omission around climate harm the ecology, play into the crime of ecocide? Shall we start with you, Kate, on that? Perhaps somebody else wants to jump in afterwards.
Yes, yeah, I'd be happy to reflect on that. I mean, one of the things in the expert group meeting, which I referred to, that we had in UCLA in February, one of the ideas that came up in trying to work out how we would, some preliminary thinking about how to craft this crime of ecocide, was the idea of introducing perhaps an element of fraud or corruption into the crime. I mean, an acceptable notion of criminal behavior into the crime, and that might be helpful. And that was for two reasons. One was because of the difficulty of conceiving how to craft the climate change or emissions-based crime in particular, which I referred to. But the other one was, of course, based on what we know is the practice that the carbon majors have been engaging in, and which has been emerging, more and more over the past year or two through a lot of this nuisance litigation in the US, and the fact that the carbon majors were so aware of climate change and deliberately covered that up seems to be such obviously criminal behavior that we thought about whether that should be included in the crime. I mean, it may be that that's not a good idea to include it as an element because it might exclude other acts which we would want to capture. Perhaps it could be an aggravating factor. I don't know, but yeah, that's something we have discussed, and I think it's something worth thinking about.
Marie, any thoughts?
Well, establishing a liability, a true responsibility for those who cause climate change is the biggest challenge that we have in front of us. And at the same time in penal law, but also in civil law. And we have a lot of intense initiatives everywhere around the world, well, especially in North America, right? In the US and Canada, to push for civil liability in that regard. We are in France and in the Netherlands pushing also to have a due diligence, duty of vigilance obligation for those companies who are among the biggest polluters, namely Total in France and Shell in the Netherlands. We are waiting for the decisions now to know, what the tribunals think of that. But this is in the future, like requiring the companies to act in a cautious way in the future. And we'll still have nothing really to hold them accountable for their actions, even though their behaviors have been catastrophic and they've known about climate change since the 60s or the 70s, and they're just now beginning to say that, yeah, they must go out of fossil fuels exploitation. And when I say they are just beginning, it's because their speeches have changed for a few years, especially the European ones. The US ones are a bit behind, but their acts aren't changing at all. So that's a real innovation in the law that we need. If we want to keep our planet safe, then we really need to find a way in the law to stop those actions from being legal. And this is to me, to my mind, and I believe to a lot of people's minds, one of the biggest challenges that we have in front of us.
Okay, here's a tricky question for all four of you, so please listen carefully, and perhaps you could each just take a brief minute, because we are running short of time, to answer, perhaps in the order that you first spoke. So starting with Philippe. Could the speakers please give one or two examples of what they believe attendees can do to support getting Ecocide made into international law? So some practical advice, please, for the 342 people, and we were nearly up to 400 at one point, who are listening now, eager to help out with this movement. Philippe, I'm afraid you're first.
Apologies, the working group is going to put out a call for submissions, so you could respond to that. But I think even more significantly, please write to your parliamentarians. What Raphael Lemkin learnt in 1945, that without the support of civil society, without people pushing, without people writing letters to their newspapers, without people writing to their parliamentarians, it is less likely to happen. And I think that is the simplest and most effective thing that you can do, is bombard. I want, if I can, Andrew, just to respond to one question, because it's an important one, and it's raised by my good friend Farhana Yamin, and that is the time element. Do we have to wait until 2030, she says, to pursue criminal actions? I don't know, but I think the question, which is an important one, underscores that time is not on our side. In writing those letters, act now. We will report within 6 months, and it will then be for others, I think, to move expeditiously. So this next year, 2021, is a very important year. Act now, I would say, because Farhana's point is absolutely right.
Kate?
Yeah, I don't have much to add to Philippe's point. I think absolutely, you know, if you're interested in sending suggestions into us, that would be fantastic, and we'd really appreciate it, and the call will be going out soon. But it's about public pressure, without a doubt. I think we were contacted actually before the session by somebody who had been responsible for the coalition for the ICC, which played such an important role in the establishment of the ICC by bringing together all those civil society groups who were pushing for the creation of the International Criminal Court. And the question was whether something similar should be put together for Ecocide. And, you know, I think that would be wonderful. I think there are all sorts of initiatives which Marie is much more familiar with than me across the world. But I think the more public pressure that we have, the more chance we have of states responding and taking a serious interest in making this law.
Marie?
Yes, my turn. So of course, support the Stop Ecocide campaign, and Jojo sent the link again in the chat. And I would advise people as well to support me. I'm sorry, because the page is only French, but I created also another page, another campaign action to help me with bringing the MEPs in favor of the recognition of Ecocide. Also, well, we created Notre Affaire à tous in France in 2015 because we believed that, you know, you can develop and support lobbying for the recognition of Ecocide. If you have legal expertise or not, you can also sign petitions. For instance, in France, the petition for in support of the citizens' proposals. We need that right now, so don't hesitate also to sign this one. But you can also use litigation to have, you know, some new rights and new obligations also recognized. So I would also encourage everyone to support, well, all the NGOs and the initiatives that move towards the recognition of an obligation to act for climate, natural rights, and all these litigation action throughout the world. So in the country that you are in.
And Nerone.
The endeavor is to establish an international crime in ecocide. The process of the ICC is necessarily an international process. So we need the assistance of everyone along the line of what Philippe has said, writing letters and persuading members of parliament, other leaders. The International Criminal Court, though, functions best when there is support in law at international level. It functions best because it cannot operate by itself. It operates at the best, particularly at the enforcement stage, when there are national laws in place. Now, it has already been mentioned that there are a number of countries who already have ecocide on their national statute as a crime. So action that we need in support of the endeavor would be both at the national level and at the international level. Keep also in mind that the ICC function on the principle of complementarity. If the national state can take action and deal with the regulation and the preservation of these environmental crimes, or the potentiality of environmental crimes at the national level, the ICC need not have to intervene. So there again, we need to strengthen the interplay of actions of necessity at the national and the international level. In respect of what our good friend Fahana has said, the time element, can we do it in 30 years? Well, I agree. The environmental damage is too much, and it's already too urgent. I don't think there is a constraint of history that binds us to waiting for another 2 decades or many decades, as the whole community waited for the development of genocide as a crime. I think that would be my response to that.
Thank you. I wonder if the 4 of you have anybody that you picture in your minds as the first person you'd like to see in the dock, and whether you'd admit to that here. But let me go on with another question sent specifically to Kate. Philippe, you might want to weigh on this too, and it's specifically about the suggestion of the creation of a coalition for an international court for the environment, and talking about the effective role of mobilizing civil society by creating that sort of coalition. And what are the necessary steps for the institution of such a court, Kate?
Oh, so this is the alternative idea of creating an international court for the environment, which, you know, I think is a really interesting idea. I mean, there are all sorts of advantages to having some kind of specialized court. You could think about the judges having particular environmental expertise, for example, which is something that would have to be perhaps provided to the judges at the ICC, the current ICC. I do think strategically the creation of a new international environmental court is perhaps not the best, not the best avenue right now. I think there's momentum behind us looking at the issue of amending the Rome Statute, which would certainly be simpler. I think to develop the support for a new international environmental court, might be quite a tall order at this point. But I mean, I certainly think it's a very interesting idea. Let's carry on with this endeavor that we're just launching now and see where that goes, I would suggest, and keep in mind the thought that perhaps an alternative would be an international environmental court.
Philippe, anything to add on that?
Yeah, no, I mean, I think the proponents of this project have been very wise in focusing on a definition, because once you've got a definition, you can then insert it in any number of different places. There could be, for example, an international convention on ecocide. There is now a draft international convention on crimes against humanity, but it's stuck at the General Assembly because, frankly, right now, many significant governments, the British and the Americans in particular, have no appetite for such an idea. And that's the big difference from 1945. I think the idea of an international criminal court also for the environment is a total non-starter. There is zero appetite for it. It's just not going to happen. And I want to use that point to segue into the elephant in this room, which is the parlous state of the International Criminal Court. Let us not mince words. It is not in a good place. I'm not here pointing the finger in any particular direction, but there is a serious question as to whether the International Criminal Court, given all the difficulties it currently faces, is right now in a position where one could neatly insert a definition of the crime of ecocide and somehow imagine that magically that institution would somehow engage, all guns blazing, and move in that direction. So let's be realistic. These things go in ups and downs. You know, there was an extraordinary moment in 1945, then nothing happened for 50 years. Then in the 1990s, a combination of horrors in Rwanda and Yugoslavia and led to the wonderful idea of the creation finally of an international criminal court, and it happened. And then for a few years, there was a little bit of hope, and frankly, it's been downhill. And many governments are turning their back on international institutions right now, including international courts. So our job is to get on with a workable definition and hope that that nudges the world to a better place in terms of the capacity and propensity and desire to really run with this idea. But let us not be starry-eyed about the state of our criminal institutions at the international level. There's an awful lot of work to do.
Okay, no starry eyes. I'm afraid we've run out of time, but you did mention 6 months, and we will hold you to that, and hopefully we can come back and see where we are and what sort of timetable for the next step. We have covered Brexit, unfortunately, magic bullets, islands, and all sorts of definitions on this issue. I think a very important, for me, fascinating selection of insights. I'm sitting here in South Africa, and the dust I can see already collecting on the windowsill from the coal power stations in Mpumalanga that are still choking us on this high, beautiful plateau. So there is that sense of urgency here, and I'm sure for all of us around the world watching this. So thank you all. Thank you to Jojo Mehta and Stop Ecocide for hosting this, and for Vanuatu and the Finnish government. And thank you to our wonderful panelists, who I think need no reintroduction, but thank you, all of you, for taking the time out in this Zoom world to make your thoughts. And see you next time.
And thank you.
Thank you, Andrew. Thank you. Wonderful, wonderful moderation.
Thank you, moderator.
Ladies and gentlemen, Your Excellencies, distinguished delegates, the International Criminal Court is more relevant today than ever before for a number of reasons. Firstly, especially in times of crisis, the world needs a judicial mechanism whereby even those in the highest political positions may be held accountable, so that no perpetrator of the crimes of most serious concern to the international community may consider themselves above the law. Secondly, in a highly globalized world, it is essential to have a judicial mechanism whereby such crimes can be established in such a way as to be applicable across many jurisdictions, something that is built into the ICC with its emphasis on complementarity with the criminal justice systems of its member states. At the same time, it is crucial that the crimes under the jurisdiction of the court are indeed those which most threaten the peace, security, and well-being of the world. Ladies and gentlemen, there is one such crime taking place right now with impunity in many parts of the world, which, despite discussion of it at the drafting stage a generation ago, remains missing from the Rome Statute to this day. It is a crime unrecognised in the legislature of most nations, and yet not only does it threaten the peace, security, and well-being of the world, it threatens the very habitability of the earth. This crime is ecocide, the mass damage and destruction of ecosystems, committed in full knowledge of the attendant risks, which include massive biodiversity loss, soil depletion, serious disruption of food chains, lethal contamination of aquifers, dangerous weather system impacts, and the exacerbation of climate change. At last year's ASP, the large ocean states of Vanuatu and the Maldives, two of the world's most climate-vulnerable countries and thus acutely aware of this global threat, had the courage to call for serious consideration of amending the Rome Statute to include a crime of ecocide. This month, the Mock COP online conference, convened, led and attended by youth from 140 countries around the world in the absence of an in-person UN FCCC conference this year, issued a declaration and proposed a global treaty listing elements the delegates considered essential for a healthy future for humanity. This treaty would oblige states to criminalise ecocide at the national level, with penalties appropriate to its severity and consequences for humanity, and in addition to support the introduction of a new international crime of ecocide, capable of prosecution as a crime at the International Criminal Court. Our foundation exists to help progress this legal route to protecting Earth's precious life support systems, and has convened a panel of international criminal and environmental law experts to draw up a legal definition of ecocide that could realistically be proposed to this Assembly by interested states. We respectfully suggest to the Assembly that serious consideration of the inclusion of ecocide into the Rome Statute, as called for by Vanuatu and the Maldives, will not only have concrete benefits with regard to the prevention of the worst excesses of environmental destruction, but constitutes a genuine opportunity for the Court in several ways. Firstly, given its deeply serious implications for habitability of the planet, ecocide is of such weight and significance that it must be addressed at the international level. Adding this crime to the Court's sphere of jurisdiction will ensure the ICC lives up to its promise in a world of accelerating ecological collapse. Secondly, as ecocide is committed first and foremost by corporate actors, criminalising it could enable the Court to function as it was intended, as a court that ends impunity for the most serious international crimes through international collaboration. Ecocide could be prosecuted in any ratifying jurisdiction, giving scope for a number of avenues to holding perpetrators to account. Thirdly, it is an opportunity for the Court to influence global culture and mindset in a way that is highly conducive to bringing peace, security and well-being to the world. This is because criminal law helps to draw moral lines, and nowhere does it do that more strongly than at this court. When ecocide becomes an international crime, the global community will begin to realise that we must treat not only each other, but the web of life that sustains us with care and respect. Ladies and gentlemen, Your Excellencies, distinguished delegates, it is time, indeed long past time, to name the crime that threatens the future of civilization on this planet and to actively help ensure its prevention. We invite you to support the call of the most vulnerable and to stand in solidarity with future generations. We invite you all to seriously consider amending the Rome Statute to include a crime of ecocide. Thank you.